Hello again. The state attorney has given former President Jacob Zuma until Wednesday to withdraw his summons, ordering President Cyril Ramaphosa to appear in court in January. He launched a private prosecution accusing his successor of being an accessory after the fact. That's after alleged misconduct, according to Zuma, in the handling of his corruption matter and private information by the lead prosecutor, Advocate Billy Downer, whom Zuma is already having prosecuted privately after the NPA said it did not find sufficient grounds to pursue that case. For more on this, we're joined by legal analyst Mpumelelo Zikalala. A very good evening to you, sir. My goodness, we've spoken to you, I don't know how many times since we first got this news last Thursday. Another extension granted from the state attorney and Ramaphosa's side, but I wonder how many extensions are reasonable before we actually have a court decide and settle the issue between the two men.
Which I think in fact, I think the most important question would be, are the extensions going to yield any results? And my answer is no. The former president is hell-bent on pursuing with his legal matters. He has full background and standing. And he's simply saying, I've been issued a certificate that I've been on long looking for, and I'm going to prosecute come hell or high waters. At the end of the day, it is the NPA that should come to the party in this matter and be able to solve the mess in which it has started by issuing a certificate which is not suspect specific. All these certificates, when they are issued, it must include the name of the suspect that is there, that is being pursued, because this is the individual that you would have looked at in terms of the merits and understood that, yes, we're not going to pursue these particular matters against this person. Now, if you are going to issue a blanket certificate like the NPA has done, they are basically saying we're abdicating our powers in terms of prosecuting as given by the law, and we are giving it to the former president to go after any other person they would like to go to, just as long as they feel that they're going to be part and parcel of it, they can be able to assist them in this case.
And just on that issue of a sort of a blanket or unsigned sort of, shall we say, unspecified certificate in terms of who the former President Jacob Zuma would have permission to go after in a private prosecution. Is that unusual that the NPA has done that or seems to have done that in this case?
I would say so. Let's look at the two certificates which are roaming around with the social media. The one which is against Advocate Billy Downer. It's specific. It says this is the suspect, this is the person that you're issuing the certificate to. The rationale behind that would have been the NPA would have sat down and then said, these are the sequence of events, these are the facts and the evidence that has been presented to us. In our opinion, we do not think that we are going to come back with a conviction in this case. Regardless of whether we want to prosecute or not, we can never get a conviction which is going to say Advocate Billy Downer is guilty beyond reasonable doubt on that basis, which is why we elect him not to prosecute. And you can go on and do your own private prosecution as allowed by the law. Now, in this case, it's quite, I wouldn't say it's disturbing, but it's quite an abnormality where you would find a certificate with no suspect at all. Then the question would be, which facts did you look at? Which sequence of events did you look at? And which suspect are you looking for? It's like charging someone and there's no individual that has been identified as the accused individual or a suspect. Who exactly are you going after if you're going to have a blank certificate? And by doing that, you are inherently giving the former president the power to prosecute any person in the country just as long as they feel that they should be part and parcel of this particular matter. So they could have easily said, we're not going to go after the president alone. We can even include the minister, any other person that is there, because the suspect has not been identified. And in terms of the court processes that are there, they are well within their rights in terms of going to court and saying, here's a certificate, we have it, and you want to issue summons against this particular individual. So this is a blunder which has been caused by the NPA, and it's only the NPA that can be able to resolve it.
And is that a leg for a Zuma case to stand on, shall we say, if indeed the state attorney holds them to court to say, well, we were issued, if that is indeed the case, with a blank check sort of private prosecution certificate, and we are using it as we see fit? Would that, in a court of law, hold as an argument?
Definitely, because they're going to say, we do not issue certificates. We're not in the business of issuing certificates. It is done so by the NPA after careful consideration of the merits and the case and the evidence which is in front of them. And if they so feel that the evidence is not there, then they issue that particular certificate and give it to us. So don't fight with us. Fight with the individual that actually signed that particular certificate and let them deal with all the other issues that are there. As we are standing now, we are at court because we've done everything according to the procedures, and we've been allowed, given this particular certificate, and we are using it to our advantage. If there's a certain loophole that has been there, then you must say kudos to the former president legal team for identifying this loophole and using it to their advantage if they so wish, and making sure or trying to make sure that the current sitting president appears in court in January. So at the end of the day, you can't really falter them. If they've been applied and they've given a certificate, they are going to use the certificate, whether it is flawed or not. It is up to the NPA to take ownership of that mistake and make sure that the NPA is able to fix it.
And in speaking to Newzroom Afrika specifically, the Jacob Zuma Foundation spokesperson, Zanele laying out, explaining quite briefly what the merits of their case are, or the basis, shall I say, of the case is that they feel that the president ignored correspondence which they sent seeking intervention after they accused Advocate Billy Downer of bias, as we know, in the corruption matter and the alleged leaking of private medical information of the former presidents, right? But in terms of process and procedure, could a court be convinced, even in a private prosecution, that it was the place of a head of state to intervene in alleged misconduct by a prosecutor, regardless of how senior, or in Downer's level at least, or at Downer's level, pardon me?
I don't think that the court could be convinced that particular argument. Our law is quite tight in terms of what the responsibilities of the president are, the responsibilities of the ministers, justice minister, and even that of the NPA. And frankly, if you look at the Constitution, it's quite prescriptive as to what the NPA can and cannot do. And the Criminal Procedure Act, which is then a further extension of those particular duties, also tells you the exact duties as to what should happen or ought to have happened in instances where you find yourself with a misbehaving prosecutor. So in this case, in the merits of it, you're quite correct. The president had nothing to do with how things ought to have been done. The president is only there just to check at the very highest echelon of making sure that justice is being served. However, the real foot soldiers as to how this prosecution should be, it is the NPA, and it is only the NPA that can take drastic measures. So all those arguments are supposed or ought to be answered when one is in court and is facing these particular charges, and that is precisely your defense. Now, but before you even get there, the person who's supposed to analyze and assess this type of defenses is supposed to be the NPA, because the response would have been to the former president. Former president, what you have submitted here is something that we do not believe is correct. The president is not really involved in what is happening within the NPA. It is supposed to be separate. We're an independent body, and we're not dictated as to how we're supposed who to arrest and who not to arrest by the president. So on that basis, we are not going to issue you this particular certificate. And if you feel that we are hard done by our decision, then let's go to court and let's fight about it and let the court decide whether we are correct or you are correct. To simply then come back and say, we are giving you the certificate, go after anyone. I think in hindsight, the NPA did not see this particular move coming. They were surprised in as much as us as South Africans, we were surprised that the sitting president has been charged with such serious charges. So at the end of the day, the merits of the matter will then be discussed at court. That's a process that you would have to go into in a forum that you need to attend before you're able to ventilate your defense.
And you make a crucial point about the NPA perhaps not having been able to foresee the twist that has now emerged. And that brings me to my next question. Given that we're fairly new to private prosecution, at least in the mainstream in South Africa, how important are cases such as Zuma versus Ramaphosa, if it does go all the way to court, in testing, establishing and defining the parameters for private prosecution and how they should be handled at NPA level and indeed in their execution?
Let's separate it into two processes or two analyses. The first one is that we are a young democracy. Our constitution has only been in existence for a couple of years, even though they may be a decade or so. However, there are certain things that we're only learning now into practice. They've always been there in terms of them written in paper. However, when they need to be practiced, it's a completely different story. Now, when it comes to private prosecutions, the Criminal Procedure Act is very prescriptive as to how things ought to have been done. And if it has not been done in that particular manner, then it should be fixed in a particular way in which it's going to be able to serve justice. For me, there's nothing wrong with it. It's a procedure that is there, being used in a proper manner, provided that all the role players are going to do their job effectively. Our real focus should be with the NPA, and then we say to them, do you really understand what it means for you to own this particular role of assessing the merits of the matter? Do you really understand your role in terms of assessing whether certificates ought to be issued or not? Do you really understand the type of loopholes that can be there if you issue blank certificates, basically giving your prosecutorial powers away to private individuals? On that basis, let's come back and make sure that we're able to close those loopholes with our monitoring and evaluation processes, and make sure that we're able to provide certificates which are going to be effective at the end of the day. But it also calls for a certain move, also for the NPA to start and complete matters within the shortest amount of time, including the assessment of whether are there matters that can be taken to court and whether convictions can be achieved if those particular trials will be able to sit. So it's an inward-looking type of process that says, let us look at how we are executing our duties. Are we doing a good enough job? Is the job in which we are doing, rightfully so, something that can be able to deliver the rights or the interests of justice in the manner in which we are looking for? But however, we must say that it is in the best interest and it is good for South Africa that you have a process or a legal system which does not discriminate against anyone, whether you are a first citizen of the country or any other person who's walking down the street. If there are anything that you need to answer in court, there are processes and ways in which you can be brought back to the legal system, brought back in front of a presiding officer, and you are able to defend your case or prosecute any other individual that is there without any fear or favor. So on that basis, I think it is quite good. I just think that the application, when it came to the NPA, they were just a bit sloppy in the manner in which they handled it.
Wow, Mpumelelo, I can't decide if we need a nap or a drink first after all of that. Thank you very much for explaining it all, Mpumelelo Zikalala.